Okay, so let's unpack this. We're doing a deep dive today into a really significant issue in India, these massively overcrowded prisons.
Yeah, it's a serious situation.
We've gathered, reports, the legal frameworks, the new laws, trying to understand how technology, specifically these algorithmic tools, might help.
Help identify prisoners eligible for release, potentially.
Exactly, to ease that overcrowding pressure, but crucially, while upholding justice. So our mission today is mapping out the legal ground, the practicalities, based on the data.
And the scale, well, it's stark. That NCRB 2022 report, it puts average prison capacity at 130%.
Wow, 130%. That impacts everything inside, doesn't it?
Absolutely. Living conditions, resources, any chance of rehabilitation, even basic security, it's all strained.
And so the idea is algorithms could maybe offer a way to sift through cases more efficiently.
That's the potential, yeah. To consistently identify eligible prisoners based on set criteria, offering data-driven insights. But the legal structure is key.
Right. You mentioned prisons are a state subject under the Constitution.
Correct. So the state governments have the primary authority, day-to-day running policies. It's them.
But the central government, the Union Home Ministry, they're involved.
They provide guidance. Think model prison manuals. They put out updated ones in 2016, 2023. And they've been, well, quite actively encouraging states to use technology.
So states operate, but the center offers a blueprint and a nudge towards tech.
Okay.
And the laws governing release itself. Big changes there recently.
Huge. We had the Old Prisons Act, state manuals, and the main procedural law was the Code of Criminal Procedure, the CRPC, from 1973.
Which just got replaced, right, as of July 1st, 2024.
Exactly. Now it's the Bharatiya Nagarik Suraksha Sanhita, the BNSS 2023. And this new law has sections directly relevant to decongestion.
And AI.
Yeah.
It's not totally new in the justice system there.
No, not entirely. It's already used for things like case management, legal research tools like SuPace, even some predictive policing pilots.
But the sources are clear. AI is meant to be an assistive tool here.
Absolutely critical point. An assistant, not the decision maker, especially when liberty is at stake.
Which brings up the whole ethical side. If you bring in algorithms, what are the big red flags or safeguards needed?
Well, several. Bias is a major one, ensuring the algorithm doesn't just replicate existing societal biases found in historical data.
Yeah, that's always a risk with AI.
And there's transparency. You need to understand why a recommendation is made, avoid that black box issue, data privacy, obviously dealing with sensitive info, and accountability.
Who is responsible if something goes wrong?
Right. And underlying all that is the absolute necessity of human oversight. The final call must be human. NTI, IOG's responsible AI principles. They touch on all this.
Yeah.
Safety, equity, privacy, transparency, accountability.
Human values. Okay, so keeping those principles in mind, how do the actual laws, especially the new BNSS, create pathways for using these algorithms?
Two main routes emerge from the sources. Pathway 1 is about premature release or remission of sentences.
Okay, and that taps into the state government's existing powers. Under the BNSS, it's sections 473, 474.
Yes. Similar powers to the old CRPC sections. It's discretionary power for the states to suspend, remit, or commute sentences.
Discretionary, but needs to be fair. So how does an algorithm fit in there?
It assists the Senate's review boards, the SRBs. An algorithm can process lots of data quickly. Offense details, time served, prison conduct, health, age, maybe risk scores, and provide sort of an initial data-driven recommendation.
Like a high-speed analyst for the board. So the steps would be state policy integrates the algorithm, train the boards that AI is just advice.
Crucially advisory, yes.
Prison superintendents use the tech to flag potential cases. The SRB reviews everything AI plus other factors.
All right, the whole picture.
Then the state government or governor decides.
Yeah.
And you'd need ongoing monitoring, audits for bias and accuracy.
Exactly. That's pathway 1. Pathway 2 is maybe even more direct, focusing on under-trial prisoners.
Under trials, people waiting for their trial, not convicted yet.
Precisely. And the new BNSS has a really significant section here. Section 479 builds on an older provision, CRPC 436A, but it's much stronger.
Stronger how?
It creates a clearer mandate, almost an obligation, to release under trials held for half the maximum sentence for their alleged offense. Or even just 1/3 for first-time offenders, provided it's not a capital case or one punishable by a life imprisonment.
And you said the Home Ministry is really pushing states on this specific section.
They are very actively urging implementation, and you can see why it's suited for automation.
Yeah, it sounds like a numbers game, almost time served versus maximum sentence.
Right. Algorithms can automatically scan prison databases, like the e-prison system, to identify under trials hitting that threshold.
Okay, that's efficient.
And BNSS Section 479, subsection 3, actually requires the jail superintendent to file an application with the court for these eligible under trials.
Oh, wow. So the system could even help with that.
Potentially, yes. Generate pre-filled applications for bail or bond based on the data. It streamlines that mandatory reporting and application step for the superintendent.
So the system flags them, helps prep the paperwork, superintendent reviews and files it with the court, then coordination with legal aid.
DLSAs, yeah, District Legal Services Authorities.
And the court makes the final call based on BNSS 479. And again, tracking how well it's working.
Correct. So for both pathways, the implementation keys the sources highlight are: start small, maybe pilot projects, ensure data quality and privacy are paramount.
Transparency is crucial, explainable AI, audits.
Accountability structures.
Yeah.
And always, always continuous human oversight. The human in the loop is non-negotiable, plus training for everyone involved.
Okay, so summing up, two clear legal avenues. One using existing state remission powers aided by algorithms. The other, a more mandatory route under the new BNSS 479 for under trials, really suited for algorithmic identification and processing, both encouraged by the central government to tackle overcrowding.
And the constant theme is AI is there to augment, to enhance efficiency, maybe consistency. It's not there to replace human judgment, empathy, or the discretion vital in justice.
It really brings it home that this isn't just about logistics or numbers. It touches on fundamental issues of justice, human rights, and whether our correctional systems actually work. It makes you think hard about how we integrate powerful tech into complex human systems fairly.
Which leads to a final thought, perhaps. Given that algorithms learn from historical data, which might contain biases, and given how absolutely critical human judgment is when someone's liberty is on the line, how do we ensure this pursuit of efficiency through AI genuinely supports and doesn't accidentally undermine the very principles of fairness and due process it's intended to serve? That's the balancing act as these systems get implemented.